this door.
Oh, it should be just gymnastics.
You gave me. This is the stuff that comes up at night. Is it the same?
It should work.
Why did I think it was the same?
When we get in, see you get in there. Well, no, that's only
That's
one
okay.
thing good for.
Why did this come up? Actually.
Oh. This actually good for us. You can get it.
What's
You
your
can
plan?
see.
I have a plan. My plan is.
Yeah. Had a good witness.
So I wouldn't like.
Morning,
Good
ma'am.
morning, ma'am.
Good morning.
Hi, what is your
What
name?
is your name?
Shantae Johnson.
Thank you.
Thank you.
Your case
Your
is
case is
scheduled at
scheduled at
9:15.
I didn't hear you, ma'am.
Your case is scheduled at 9:15, so you can just stay where you are if you want, or you can come back, whatever you want to do.
I think I'll just come back in about 5 minutes.
Okay, sounds good.
All right, bye-bye.
Bye.
Like, Ida Page hasn't turned in no keys or nothing.
Good morning, Miss Samples.
Good morning, Mr. Cox.
Good morning.
I'm not quite ready for you yet. We're still about 6 minutes to 9. I start promptly at 9. So if any of your cases get here, Marianne will put you into a breakout room with them. Otherwise, we'll get going.
Thank you very much, Your Honor.
Sir, who just signed on, who has the hat on, can you hear me?
Yeah. Yes.
Hi, what is your name, please?
Christopher Rowe, ma'am. Your Honor.
All right, thank you. To the person who just signed on and is identified as T8 Pro, can you hear me?
You mean ROE?
No, I'm sorry. No, it does sound like that. No, it's somebody else that's on the screen. I've got you identified, Mr. Rowe.
Oh, thank you, Your Honor.
Yep. The person who just connected is T8 Pro. Can you hear me?
Good morning, everyone.
Morning.
Today is
Morning.
Wednesday. Wednesday, April 5th, 2023. I am Judge Martin. This is courtroom number 1. Our docket today is exclusively landlord-tenant cases. If you do not have a landlord-tenant matter, you are in the wrong courtroom. If you're not sure, you may send a chat to Mary Ann. She'll help you get where you are supposed to be. Attorneys, you have been made co-hosts. You are free to move your tenants into breakout rooms or meeting rooms to discuss the matters and then come back on. Cases are scheduled in 15-minute time blocks. I will start taking defaults or dismissals. I'll take dismissals right away, but I'll start taking defaults approximately 15 minutes after the scheduled start time. Other than that, Mary Ann, is there something ready to go?
No, ma'am, not yet. There,
All that lead up for nothing.
Ms. Sheed, I did make you co-host, and Mr. Rowe, Christopher Rowe is here if you need a breakout room with him.
Yes, I'm just pulling up his information. If you, I can do that if I'm a host. Right? You said that we're made co-hosts.
Correct.
You're made a co-host, correct?
Yep, I see it now. Okay. Yes, I will take care of that one.
Thank you, ma'am.
No problem.
The person who's identified as T8 Pro, can you hear me?
Yes,
What is your name, please?
Tanisha Williams.
Thank you.
You're welcome.
Ms. Sheed, what I'll do is when I get some of your defendants, I will just put them in your waiting room. Is that okay?
Yes, that's fine. I was just moving the managers into their appropriate spots as well.
Thank you. The person who's identified as Zoom user, can you hear me? Oh, that's not a good start.
Mary Ann, don't say that. It's a
All right,
wonderful
sorry,
start
take it
to
back.
Good morning. Can you hear me?
Yes, Ms. Johnson, good morning.
Good morning.
Ms. Carter, you missed this morning's lecture. Mary Ann has made you or will be making you a co-host. If you see any of your defendants, feel free to pull them into a meeting room, talk to them about the status of their matter, come back to this main session. I try to call cases as close to the scheduled starting time as possible. I'll take defaults about 15 minutes after the scheduled start time. Thanks, Mary Ann.
Mr. McCausland, Miss Nellum's just joined. Do you want me to put her in your, you can move her around.
I was just trying to figure out how to do that.
I can put her in your meeting room for you if you want me to.
That would be great. Thank you.
You're welcome.
Hello, good morning.
Good morning, ma'am. Ms. Gahn?
Yes, good morning.
Good morning, ma'am. We're going to get you properly labeled. I have not seen anybody from Mr. Pallett's office yet, but if you sit tight, when they get here, we'll get you matched up and get you into a meeting room to discuss your case, okay?
Okay, thank you.
Thank you.
Bye-bye.
Dominique Johnson, you should see an invitation to join a breakout room. If you could please click on that.
Marianne, if you would check with security to see if there's anyone waiting to use the Zoom room. My concern is that Judge Oakley has a docket as well, and if he has a Zoom person, there might be somebody waiting to join us.
Sure.
Thank you. This is 230954 LT. This is Federal Home Loan versus Daniel Curley. And Shayna Blackburn.
Good morning, Judge. Sogol Plaggedy, P69690 for the plaintiff.
Good morning, ma'am. Good to see you.
Yeah, good to see you too, Judge.
This case was scheduled at 9 o'clock. It's now 9:15 by the court's clock. Is there anyone here from 27567 Mockingbird Drive, Flat Rock? Case having been scheduled at 9 o'clock, it now being 9:15 by the court's clock. Uh-oh. Defendants having failed to appear, ma'am, how do you wish to proceed?
Judge, we would ask for a default judgment for possession only with a writ to issue on or after April 17th, 2023.
Defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with a writ date of April 17th, 2023. Ma'am, if you would submit that default judgment to the court by email, you can email it to the court civil department.
Yes, I got the email from Marianne a few moments ago.
Anything else this morning?
Not for plaintiff.
Have a good day. Good to see you.
You too. Thanks, Judge. Bye.
Thank you. Bye-bye. This is 230940. This is Swan Creek versus Anthony Lombardo. Anthony Lombardo, or anyone at 38905 Carlisle, number 48. Your appearance, sir.
Good morning, Your Honor. Aaron Cox. I'm appearing on behalf of the plaintiff. Your Honor, today is the date and time set for an adjourned hearing on plaintiff's complaint for non-payment of rent. The defendant did not appear at the first hearing. He has not answered the court's call now. I would ask the court to enter a default judgment. The rent to retain is $4,352.27. We have court costs in this matter of $164. The total is $4,516.27. And we'd ask if that amount remains unpaid, an order of eviction could be issued after April 17th, 2023.
Defendant having failed to appear, this case being scheduled at 9 o'clock, is now 9:17 by this court's clock. Default judgment shall enter in favor of plaintiff and against defendant with the terms just placed on the record. Mr. Cox, if you'd have your office submitted to the civil department by email. Anything else this morning, sir?
Nothing from me, Judge. I'll get that email out shortly.
Take care, sir.
You as well, Your Honor. It's good to see you.
Thank you. Good to see you. Good morning, Mr. Ravitz.
Good morning.
Mary Ann has made you a co-host. If you see any of your defendants, please feel free to move them into a breakout room, a meeting room. After you've had a chance to speak to them, come back to the main session. I'll get your cases called for you, okay?
Sure, thank you.
Thank you. Mr. Burcroft, good morning, sir.
Good morning, Judge.
Mr. Ravitz, there are two people in your waiting room.
Okay, thank you.
You're welcome.
I heard you.
Mr. Robert, can you hear me?
Hello?
Mr. Morton, are you ready with something, sir?
Yes, I am, Your Honor. It's in regards to Rawsonville versus Nina Gunn, 23-0811LT.
230-811-LT, Rawsonville Woods versus Nina Gunn. Your appearances, please.
For the record, Your Honor, Attorney Ian Morton of Palace Law on behalf of Rawsonville.
Ms. Gunn, state your name for me, ma'am.
Nina Gunn.
Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding?
Your Honor, the parties have spoken and have agreed to enter into a proposed consent judgment agreement. Rents retained are $5,131.68, core costs of $164 for a total of $5,295.68. I did advise Ms. Gunn of her rights under MCR 4.201 as I explained it to her. First one is this agreement would not be final for 3 business days, and Friday doesn't count because it's Good Friday. Additionally, she does have the right to appeal the case as well. Further, she did give me permission to sign her name to the agreement. Was electronically based on the fact that we are all remote right now.
Thank you. Ms. Gunn, you were able to hear Mr. Morton just now?
Yes, ma'am.
And it's your agreement that there's a total of $5,295.68 due, which includes court costs?
Yes, ma'am.
And he explained your rights to you regarding the consent judgment
Yes, ma'am.
and your rights regarding the appeal.
Yes, ma'am.
And you've authorized him to sign your name to the consent judgment with the terms that he just placed on the record.
Yes, ma'am.
Did you have any questions, ma'am, about the hearing this morning?
No.
Ma'am, the court will enter the consent judgment that is presented by Mr. Morton's office. A copy will be mailed to you at the address we have on file. Anything else in this case, Mr. Morton?
No, Your Honor.
Ms. Gunn, you are free to go. You have a wonderful day.
Thank you, everybody. Happy Easter.
Thank you, Ms. Gunn.
Happy
You as
Easter,
well.
ma'am.
Thank you. Bye-bye.
She just got pounded
Do you
for
have
6
anything else ready,
roommates, I
Mr.
think.
Morton?
Your Honor, I've not run across any other tenants so far. I'm gonna start looking again.
Thank you. Mr. Robert, why are you outside, sir?
The lady at the desk said we could do it out here.
Sir, your case is not scheduled until 9:45. We will put you into the waiting room to speak to the attorney from, or the representative from West Village, okay?
You so mean. You so mean.
Mr. Ravis, you have something ready?
Yes, I have one case ready. Dominique Johnson's a tenant. Case number is 0858.
Yes, I.
This is 23-0858 LT. This is Wellesley Townhomes versus Dominique Johnson. May I have your appearances, please?
Lee Ravitz, P25314, on behalf of the plaintiff. Ms. Johnson is here, and we've met in the break.
Yes, I am here.
State
Does
your
your
name,
name,
ma'am.
please?
Dominique Johnson.
The parties have agreed to enter into terms of a consent judgment, the terms of which are as follows. The rent to retain possession, including April's charges, is $1,350, 1350, $164 in court costs, total of $1,514. That'll be paid by April 17th, or money or a record issue after that date. There's not a request for a money judgment, and Ms. Johnson's given me her approval to sign this consent judgment on her behalf.
Ms. Johnson, were you able to hear Mr. Ravis just now?
Yes, ma'am, I was.
And it's your agreement that there is a total of $1,514 due in this matter. That includes court costs?
Yes, ma'am.
And because you appear virtually, there's not a signed consent. You've authorized Mr. Ravis to sign your name to that consent judgment?
Yes, ma'am.
And ma'am, you understand that because Mr. Ravitz represents the complex and you do not have an attorney, the judgment will not be final and enforceable for 3 days.
Yes, ma'am.
You also understand that you have 10 days to appeal today's consent judgment.
Yes, ma'am.
Do you have any questions, Ms. Johnson?
No, ma'am.
Mr. Ravitz's office will email that proposed consent judgment to the court. I will sign it and a copy will be mailed to you at the address we have on file. Anything else in this case, Mr. Ravitz?
No.
Ms. Johnson, you are free to go. You have a wonderful day, ma'am. Thank you.
You too. Thank you.
Thank you.
Sir, stop yelling at them.
Ooh, Marianne, it's your fault. This is 230867 LT. This is Cascade Funding versus the estate of Pearl Brown.
Good morning, Your Honor. Donna Carter, P52369, appearing on behalf of Cascade Funding.
The estate of Pearl Brown or anyone at 6291 Edmond. Today is the day and time set for the second hearing in this case. It appears that no representative appeared on behalf of the defendant in this matter back on March the 22nd. We are a little bit before the court's usual default time. The case was scheduled at 9:15. It's now 9:28 by the court's clock. There is no one responding to the call on behalf of the estate of Pearl Brown or anyone at 6291 Edmond Street. Ms. Carter, how would you like to proceed?
If we could enter a default judgment with writ to be on or after the 17th of April.
Case having been scheduled at 9:15 is 9:28 by the court's clock. Defendant having failed to appear, default judgment will enter in favor of plaintiff and against defendant with a writ date of April 17, 2023. Ma'am, if your office would submit that default judgment by email to the civil department, the court will enter it.
We will do
Anything
that.
else in that case?
No, Your Honor, thank you.
Thank you. This is 230938 LT. This is US Bank versus Joy Ferris.
Good morning, Your Honor.
Joy Ferris or anyone at 44205 Ecorse Road in Van Buren Township. Ms. Carter, my apologies.
No problem. Donna Carter, P52369, appearing on behalf of US Bank National Association.
Today is the day and time set for the second hearing in this matter. Defendant failed to appear at the first hearing on March 22nd, 2023. Has failed to respond to this morning's call. Case is scheduled at 9:15. Is now 9:29 by the court's clock. Defendant having failed to appear. Ma'am, how do you wish to proceed?
With entry of a default judgment and writ to issue on or after April 17th, 2023.
Default judgment shall enter in favor of plaintiff and against defendant with a writ date of April 17, 2023. Ms. Carter, if you would have plaintiff's office submit a default judgment by email to the civil department, the court will sign that. Anything else this morning, ma'am?
That will be all. Thank you, Your Honor.
Have a good day.
You too.
I
Mr.
do have a
Ravitz.
consent. I have a consent on, yes.
230857 LT. This is Wesley Townhomes versus Porter. May I have your appearances, please?
Lee Ravitz, P25314 on behalf of the plaintiff. Ms. Porter,
Mr. Ravitz, you have to bring people out of the breakout room.
I told her to come.
She's in there. I just sent a request.
Okay, thank you.
You're welcome. Thank you. Ms. Porter,
Yes,
state your name for me, please, ma'am.
I'm sorry, Shantia Porter.
Thank you. Today is the day and time set for the second hearing. Mr. Ravitz, how are we proceeding?
Here are the parties have entered into the terms of a proposed consent judgment. The terms are as follows. The rent to retain possession, including April's charges, is $564, $164 in court costs, total is $728. That'll be paid by April 17th. I explained this to Ms. Porter and she's given me permission to sign her name to the proposed consent judgment. She did tell me she sent a money order in today for a portion of this. It has not been credited as of yet.
Oh,
Thank you. Ms. Porter, is there something
Yeah.
wrong with your video, ma'am?
I don't know what it jumped on the lady.
Okay,
me-
Ms.
Okay,
Porter,
there.
you
Yes,
were able to hear Mr. Ravish just now?
yes, ma'am.
And it's your agreement that there is a total of $728 due and owing that includes court costs?
Yes, ma'am.
And you've agreed to entry of a consent judgment with Mr. Ravish this morning?
Yes, Your Honor.
And ma'am, because you appear virtually, there's not a signed consent judgment in the file. Have you authorized Mr. Ravish to sign your name to a consent judgment?
Yes,
And you understand that because he represents your apartment and you are unrepresented, the judgment will not be final and enforceable for 3 days.
yes,
You also understand that you have 10 days to appeal the judgment in this matter.
yes.
Do you have any questions, Ms. Porter?
No, ma'am.
Thank you. Mr. Ravish's office will email the proposed consent judgment to the court. I will sign it and a copy will be mailed to you at the address we have on file. Anything else in this case, Mr. Ravish?
Nothing else.
Thank you. Ms.
Thank
Porter,
you.
you're free to go. You have a wonderful day, ma'am.
You do the same. Thank you. Thank you.
Thank you. Mr. Morton.
Yes, Your Honor. Was it I have Mr. Parker and Mr. Ford, I'm sorry, Mr. Parker and Miss Ford, excuse me. That's a 930 case, 23-0847.
This is 230974 LT, West Village Estates versus Sharice Parker and Kenyon Parker.
I think it's
No.
was it Marcellus Parker and Abigail Ford.
Let's try it for, again, Mr. Morton, 230847 LT, Holiday Woods versus Marcellus Parker and Abigail Ford.
For the record,
Your
Your Honor.
appearances, please.
For the record, Your Honor, Attorney Ian Morton of Palace Law on behalf of Holiday Woods.
Mr. Parker, state your name, please.
Marcellus Parker.
And where is Ms. Ford?
She's right next to me.
State your name, please, ma'am.
Abigail Ford.
Thank you. Mr. Parker, take your cap off for me, please. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties have spoken. They've agreed to enter into a proposed consent judgment agreement. Rents retained are $4,651.10. Court costs of $198, total of $4,849.10. I did advise them of their rights under MCR 4.201, specifically the fact that this agreement would not be final for 3 business days, including the fact that this Friday is Good Friday. Additionally, I advised them of their rights to appeal. Further, they did give me permission to sign their name to the proposed consent judgment agreement since we were all appearing remote. And I advised them of the payment date of April 17th, 2023, based off of the statutory time period being elongated because of the weekend.
Mr. Parker and Ms. Ford, were you able to hear Mr. Morton just now?
Yes.
And it's your desire to enter into a consent judgment that has a total due of $4,849.10?
Yes.
Yes.
And Mr. Morton explained to you your appeal rights and you've agreed to allow him to sign a consent judgment on your behalf?
Yes.
Mr. Parker, do you have any questions in this matter?
No, ma'am.
Ms. Ford, do you have any questions in this matter?
No, ma'am.
Mr. Morton's office will email the proposed consent judgment to the court. I'll sign it and copies will be mailed to you at the address we have on record. Anything else in this case, Mr. Morton?
No, Your Honor.
Mr. Parker and Ms. Ford, thank you for your patience this morning. You're free to go. Have a wonderful day.
Thank you, you as well.
Thank you.
Megan, you should see an invitation to join a breakout room. Can you please click on that?
Maybe your landlord. Farmington Hills condo.
Mr. Morton,
Yes, Your Honor.
Did you have something next ready?
No, I'm gonna go back to the breakout room. I'm continuing to monitor, see if anybody else appears.
If you have a moment though, sir.
Yes.
This is 230820 LT. This is Rawsonville Woods versus Tina Sieber. Tina Sieber or anyone at 277 Rustic Lane in Belleville.
If I may, on this matter, Your Honor,
I'm sorry.
if I may, Your Honor, this one's gonna be dismissed. I can put that on the record.
Thank you.
Oh, I just spoke to my client this morning. They confirmed that a payment that was submitted had cleared, which then brought them to a zero balance at the end of, was it March? Therefore, they were paid in full at that time. So we will move to dismiss this case without prejudice, Your Honor, and I will submit a dismissal to the court stating as such.
Thank you, Mr. Morton. I'll make a notation in the file that the dismissal is on its way. This is 230825 LT. This is Rawsonville Woods versus Therese Holyfield and Samuel Holyfield. Or anyone at 235 Creekside Drive in Belleville. This case was scheduled at 9:15, is now 9:38 by the court's clock. There is no one responding to the call. Mr. Morton.
Thank you, Your Honor. At this time, we'd ask a default judgment for possession to be entered. Rents retained are $3,375.67. Court costs of $198, for a total of $3,573.67. This is a default judgment for possession only. I would also just formally state for the record that at the last hearing.
Hello? Yeah, Ms. Anderson, can you hear me? Yes. So I don't.
I would just state for the record that at the last hearing, a party appeared that stated that they was living there now, but they were not listed as an approved occupant. So we were looking to see if they were going to appear again. And they had spoken to my client one time, but no other movement had occurred. So therefore, we are moving forward for entry of a default judgment.
Thank you, Mr. Morton. This case having been scheduled at 9:15, it's being 9:38 by the court's clock. Defendants having failed to appear, and the occupant from the first hearing failing to appear at the second hearing, default judgment shall enter in favor of plaintiff and against defendant. Total due of $3,573.67. Your office will submit that by email, would be most appreciated. This is 230827 LT. This is Rawsonville Woods versus Kaylee Tundis, James Wright, or anyone at 128 Rustic Lane in Belleville. This case having been scheduled at 9:15, it now being 9:39 by the court's clocks. There's no response to the call. Mr. Morton.
Here at this time, we'd ask a default judgment for possession be entered. Rents retained are $2,259.56. Court costs of $198, for a total of $2,447.56, Your Honor.
They keep showing steady.
Thank you. Case having been scheduled at 9:15, it being 9:40, defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with a total due of $2,447.56. Plaintiff's office will submit that judgment by email for entry.
Actually, Your Honor, just to correct one small thing, it was $2,457.56. That was my math error.
Thank you, Mr. Morton.
Thank you.
Mr. Ravitz, the last name of your tenant.
I have a 9 o'clock case. The tenant has not appeared. It's a first hearing. Kirkpatrick.
Not a first hearing with me.
Oh, you're right. It's a different courtroom. I apologize. Okay.
That's okay. Don't apologize.
My next hearing for you is not till 10 o'clock, so I'll be back in a little bit.
I'll see you at 10 o'clock, sir. Thank you.
Thank you.
Mr. McCausland, are you ready? With Ms. Nellums? Mr. McCausland?
Probably.
Mr. McCausland? And that is how your cases get passed. Mr. Morton, did you have something else, sir?
No, Your Honor, but I just saw that Ms. Tundis just logged in.
Of course you did. Let me pull that file back.
Excuse me, I've been here since 9:15.
I'm sorry?
I've been here since 9:15, ma'am.
So when I called your name, is there a reason why you didn't respond?
I didn't hear you call my name, ma'am. I'm sorry. It wasn't called.
You'll see an invitation to go into a breakout room with Mr. Morton. Please go there with him to discuss your case, okay?
Okay, ma'am. Thank you. I'm sorry.
Thank you. No worries. This is 230886 LT. This is Willow Glenn versus Brandy Nelms. May I have your appearances, please?
John McCausland representing the plaintiff.
Ma'am, if you would unmute yourself, please, and state your name for the record.
My name is Brandy Nellum.
Today is the day and time set for the second hearing in this matter. Mr. McCausland, how are we proceeding?
We've agreed to the terms of a consent order of conditional dismissal.
Those terms?
Those terms are the current rent to retain possession is $3,550. Court costs $164 for a balance owing today of $3,714. However, this is a termination of tenancy action, and the conditional dismissal provides that defendant must vacate by April 18th, 2023, and must also pay this sum of $3,714 less the security deposit by August 31st, 2023, or the dismissal may be vacated and judgment may be entered for the remaining balance. If the April rent to be prorated if the defendant vacates by April 18th.
Ms. Nelms, you were able to hear Mr. McCausland just now?
Yes, I am.
And the terms that he placed on the record are an accurate recitation of your agreement with him.
It's accurate, but I just need clarity on one thing. I know I talked to him about it, but I just want to ask again that with the conditional dismissal, it would not affect me negatively. It would only affect me negatively only if I default on this, on our agreement. Correct? Is that correct?
That's correct, ma'am.
Okay, all right. That's what I needed to know. Thank you.
And because you appear by Zoom, there is not a signed conditional dismissal. Have you authorized Mr. McCausland to sign your name to it? Or will
Yes,
you
I
be
did.
circulating it by email? Okay.
Your Honor, I've also advised her that she has a 3-day right to request the court set it aside if she has a good reason. For example, if I have misled her in any way.
You understand that, ma'am?
Yes, I do.
Do you have any questions?
No, not right now.
Thank you. Well, now is the time.
No, ma'am.
Mr. McCausland's office will submit that proposed conditional dismissal to the court by email. I'll sign it and copies will be mailed to you at the address we have on record, okay?
Thank you, Judge.
Have a good day, ma'am.
Thank you, Your Honor.
This is 230884 LT. This is Willow Glenn versus Tosha Howe, H-O-W-E, Tosha Howe, or anyone at 9446 Biddle in the city of Romulus. Tosha Howe. Give me 1 second. Let me look one more place, Mr. McCausland. This matter was scheduled at 9:15. It is now 9:46 by the court's clock. There is no one responding to the call in this matter. Mr. McCausland, how would you like to proceed, sir?
Your Honor, I would request a default judgment of possession be entered, indicating that the rent to retain possession is $900. The allowable court costs are $164 for a total judgment amount of $1,064. If that amount is not paid by April 17th, an order of eviction may issue.
Thank you, sir. Case having been scheduled at 9:15, it's 9:46 by the court's clock. Defendant having failed to appear, default judgment shall enter with total due to plaintiff of $1,064, which includes court costs. The writ date will be April 17th. Mr. McCausland, if your office would submit that proposed default judgment by email, the court will enter the same.
Thank you.
Anything else in that case, sir?
Nothing in that case.
This is 230880 LT. This is Willow Glen versus Rebecca.
Good morning. How you guys doing?
Rebecca Chapman, or anyone at 9546 Biddle. Case is scheduled at 9:15. It's now 9:47 by the court's clock. Defendant appears to have failed to appear this morning. Mr. McCausland, how would you like to proceed, sir?
We'd ask for a default judgment of possession. Your Honor, the current rent to retain possession is $1,485. The allowable court costs are $164 for a total judgment amount of $1,649. We'd ask that the judgment indicate that if that amount is not paid by April 17th, 2023, an order of eviction may issue.
Thank you, sir. Case having been scheduled at 9:15, it being 9:47 by the court's clock, defendant having failed to appear. Default judgment shall enter in favor of plaintiff and against defendant with total due including court costs of $1,649. Plaintiff's office to submit that proposed judgment for entry. Anything else this morning, Mr. McCausland?
That's it for me, Your Honor. Thank you very much.
Thank you, sir. Have a
All
good
right.
day.
You too.
Thank you. Mr. Joseph.
Judge, do you mind passing my matter for 2 minutes? I'm dealing with a personal matter.
Nope, go ahead. I'll call you when
Thank
you
you.
turn your screen on. This is 230936 LT. This is Huron Estates versus Shauna Ruiz and Brandon Fondren.
Good morning, Your Honor. Jenny Scheid on behalf of the plaintiff, P64886.
Shauna Ruiz or Brandon Fondren, anyone at 22014 Petite Site 213 in the city of Romulus. This case was scheduled at 9:15. It's now 9:49 by the court's clock. There is no one responding to the call, ma'am. How would you like to proceed?
We're requesting a default judgment be entered against both defendants. We did not have them in the breakout rooms either. So this is a termination of tenancy case, Your Honor. As a mobile home, we are requesting the default judgment and for them to vacate by April 17th, 2023. It's my understanding that neither of them are in the military, minors, or incompetent, and the property has been kept fit for its intended use by the plaintiff.
Thank you, ma'am. There are no unidentified persons in the court's virtual breakout rooms. There's no one in the court's virtual waiting room. There is no one here in the courtroom in this matter. Default judgment shall enter in favor of plaintiff and against the defendant in this termination of tenancy matter. This
Thank
is
you.
230975 LT. This is West Village Estates versus Ida Payne. Please state your appearances for the record.
Jenny Scheid on behalf of the plaintiff, P64886. Ms. Payne?
Ms. Payne?
Yes.
State your name for me, please, ma'am.
Ida Payne.
Thank you. Today is the day and time set for the second hearing in this matter. How are we proceeding?
Your Honor, we spoke in a breakout room. Ms. Payne and West Village have entered into an agreement. Ms. Payne will vacate the property by April 17th, 2023. I have advised her of her rights under MCR 4.201I. With her permission, I would like to seek her permission to sign this on her behalf.
Yeah. Yes,
Ms. Payne, you were able to hear everything she just said?
yes, ma'am. I hear.
And it's your agreement that you will vacate by April 17, 2023?
Yes,
And she explained to you that because she represents West Village and you are unrepresented, the judgment will not be final and enforceable for 3 days.
okay.
And ma'am, you understand you have 10 days to appeal this judgment.
Okay.
You understand that?
Yes, ma'am. Mhm.
And ma'am, because you appear by Zoom, there is not a signed consent judgment. Do you authorize plaintiff's office to sign your name to the proposed consent judgment?
Yes,
Ma'am, they will sign your name to that proposed consent judgment submitted to the court. I will review it, sign it, and a copy will be mailed to you at the address we have on file. Do you have any questions, Ms. Payne?
No.
We'll also send a copy to the manager on site, to Renee Samples. If you want to get a copy, you can get one from her.
Okay.
Thank you. Ms.
Thank
Payne,
you.
thank you for your patience this morning, ma'am. You're free to go. You can just let yourself out of that door to your left.
Okay, thank you.
Have a good day, ma'am.
You too, dear.
Thank you. This is 230977 LT. This is West Village Estates versus Christopher Rowe.
Good morning, Your Honor. Jenny Shine on behalf of the plaintiff P64886. Mr. Rowe was here earlier, but he had to return back to work. We did enter into an agreement though, but because he was literally at work in his large machine, I'm not sure what it was called, I told him I would put it on the record for us so that he could get back to work.
And what is that agreement, ma'am?
So we're going to do a conditional dismissal for Mr. Rowe. It's going to be a payment plan for him to pay back the $6,951.61 that he currently owes. The conditional dismissal is for him to pay $2,000 per month in addition to his rent over the next 4 months until it is paid. He understands that there will be additional late fees that will be added each month until it's paid off. He understands that if he pays it off early, that it would save him some late fees. We're going to send this over to him for signature. So I'm not sure if you want to do this as a control date. I do have his email
We will
address.
do that. Okay, as long as you have his email address, if you would circulate that to him, please. Otherwise, what the court will do is adjourn it over to next Wednesday, April the 12th at 11 a.m. by Zoom. But if you circulate it and get it emailed over to Sandy downstairs before that date, we'll take it off of the docket, of course.
Understood. We
Thank
will
you.
get that taken care of.
Thank you, ma'am. This is 230983 LT. This is West Village Estates versus Jerisha Williams.
Your Honor, Jenny Scheid on behalf of the plaintiff, that one we should have received a dismissal for.
The last time I checked for the dismissals was about a half an hour ago. I know they're a little backed up downstairs,
Okay.
but I'll make a notation in the file that it's forthcoming.
Yes, and if you need me to, I can put in an oral motion to do that.
I've already written it on the fly of the file. It's fine.
Thank
This
you.
is 230991 LT. This is West Village Estates versus Katera Williams and Tanisha Williams.
Jenny Scheid on behalf of the plaintiff.
Miss Williams,
Yes, I'm here, Tanisha Williams.
and where's Katera Williams?
She's at work.
Ms. Scheid, how are we proceeding this morning?
Your Honor, because Katera Williams has not appeared today, we are requesting a default as to her. She would be listed as defendant 1. As to Tanisha Williams, defendant 2, we have reached a consent agreement. They are going to pay their balance by April 17th, 2023. Currently, the rent to retain is $4,342.56. Court costs are $199.20. For a total owed of $4,541.76. Again, for them to pay or vacate by April 17th, 2023. I did advise Tanisha Williams of her rights under MCR 4.201I to have this set aside within 3 business days.
Ms. Williams, you were able to hear the attorney just now.
Yes, ma'am.
Would you turn your video on for me, please, ma'am? And ma'am, it's your agreement that there's a total of $4,514.76 due and owing?
Yeah.
And you wish to enter a consent judgment with those terms?
Yes.
And the attorney explained to you that because she represents the complex and you are unrepresented, the judgment will not be final and enforceable for 3 days.
Yes.
And also that you have 10 days to appeal the decision.
Yes.
And because you appear virtually, there is not a signed consent judgment. Have you authorized her to sign your name to that consent judgment?
Yes, I did.
Ma'am, her office will email a consent judgment over as to you. The judgment will appear as a default as to Katera Williams. Once the court signs it, copies will be mailed to you at the address we have on file. Do you have any questions, Ms. Williams? Ma'am?
No, I don't.
Thank you. You're free to go. Have a good day. Thank you for your patience this morning.
Thank you.
Thank you. This is 231082 LT. This is Huron Estates versus Megan Ibbotson.
Jenny Scheid on behalf of the plaintiff.
Ma'am?
Oh, yes, it's Megan Ibbotson. You were close. It's very close.
Ma'am, state your name for the record, please.
Megan Ibbotson.
Would you turn your video on, please? Today is the day and time set for the second hearing. How we proceed.
Oh, that's what happened.
Your Honor, we did speak with Ms. Ibbotson in a breakout room. Ms.
It's all on
Ibbotson,
now.
this is a termination of tenancy case. Ms. Ibbotson has agreed to vacate the property by April 30th, 2023. So this is a consent judgment. I did advise her again of her rights under MCR 4.201I that she could set this aside within 3 business days for good cause.
Ma'am, is it your agreement to vacate the premises on or before April 30th, 2023?
Yes.
And Ms. Scheid explained to you your rights to set aside the consent judgment or otherwise appeal this matter.
Yes, she did.
And because you appear on Zoom, there is not a signed consent judgment in the file. You've authorized her to sign your name to that consent judgment?
I absolutely do.
Do you have any questions in this matter, ma'am?
No, I do not.
Her office will prepare the consent judgment, email it over to the court. I'll sign a copy and it will be mailed to you at the address we have on file. Thank you for your patience this morning. You are free to go. Have a good day.
Thank you. You too, Your Honor.
Thank you. Mr. Joseph, you're listed as American Presidential. I don't have anything on my docket under that plaintiff's name. What are you here for?
Thank you, Judge. We actually submitted a consent judgment to the court yesterday, but we couldn't get confirmation, so it could have been removed. We appeared just in case, and the defendant was here as well.
What's the defendant's name, sir?
Jacqueline Stiltner, Stiltner.
I don't have it, but I see you and I've seen Ms. Stiltner here this morning, so I'll send it back down with a notation that there is. Oh, I was looking for something else. Just so we're clear, this is 230866 LT, American Presidential Estates versus Jacqueline Stiltner. I was looking for Mr. Piper. That's what it was.
Oh.
I don't have it, but what I'll do is I'll send it back downstairs for the civil department to match it up to the court file. Was there anything else this morning, Mr. Joseph?
No, I was just, if the court needed, I was going to put the terms of the consent on the record, but like I said, we faxed it in yesterday.
If you want to, that'd be great. Thank you, Mr. Joseph.
Yeah, thanks, Judge. So just pursuant to the terms of this agreement, parties have agreed to a consent judgment of possession, total rent retained $4,096, costs are $155 for a total judgment amount of $4,251 with a writ to issue after April 28th. The rights under 4.201 specifically regarding the 3-day rescission rule were explained to Ms. Stiltner, and she has agreed to having us sign her name to this consent agreement.
Ms. Stiltner, is everything Mr. Joseph said true and accurate?
Yes, it is, ma'am.
We did not receive it from, well, it's not in the court file. I'll match it up to what Mr. Joseph has submitted. The court will sign it and copies will be mailed to you at the address we have on file. Thank you for your patience this morning, Ms. Stiltner. You have a wonderful day. You're free to go.
Thank you, Judge. Have a good one.
Thank you.
Are the parties here on 230930 LT? This is McConnon Tetla versus Shantu Johnson.
Yes, ma'am.
Yes, Your Honor.
Yes, Your Honor. Who's here?
Danette McLemore appearing on behalf of the defendant. The defendant is also in the courtroom.
And Noreen Constantine on behalf of the plaintiff.
Have the two of you spoken this morning?
We have not spoken this morning, but we did speak last week, and we were not able to work anything out.
How are we proceeding this morning?
Your Honor, I'm asking that the complaint against the defendant be dismissed, Your Honor. I don't believe that there's a basis for it. It's a termination of tenancy case. The client has, or Miss Johnson has a lease. It's for a year. She was given a 30-day notice by text to vacate. And again, at this point, this is a landlord-tenant termination of tenancy case. She has not been, she has a lease, and the lease was just entered into in November.
Ms. Constantine?
Yes, she's been making it impossible to maintain the property. She contacted my client in December and said there was a major plumbing issue. So he sent his, he has a carpeting store as well as a couple of other rentals. So he has employees, and he sent his worker over there who went to Home Depot and got supplies. And when he went back to the property, Miss Johnson wouldn't let him in. So Miss Johnson claimed that there's so much damage, which we weren't able to discern. And she wants $6,000 so that she can make the repairs herself. And she also claimed the washer and dryer weren't working. So my client said he'd bring another set over.
Your Honor.
She's making it impossible.
No. I'm sorry. The two of you don't have an agreement, and this is in fact a disputed matter. We need to schedule it for a trial date.
Well, Your Honor, just on its face, this is a termination of tenancy case. And the complaint alleges it was terminated with a 30-day notice. You cannot terminate a lease with a 30-day notice unless there is a lease violation. There's no lease violations alleged here. The only violation is the only allegation that's raised in the complaint is that there was a 30-day notice given. There was, and
Ms.
again,
Ms. McLemore, I'm interrupting you because you see the other 18 people on the screen the same way I do, correct?
Yes, okay.
And let's do some more of this. You saw me waving my hand at Ms. Constantine, correct?
Yes.
And what I started to say was because the two of you do not have an agreement, we will schedule a matter for hearing where the court will take up your issue regarding the validity of the notice to quit. We won't do it with 18 other people waiting for their cases to be heard, and we don't do it by attorneys screaming out stuff. I mean, that's
okay, I'm sorry, Your
as
Honor.
I can say it. We're all on the same page. We're just going to do it in a more orderly fashion.
Thank you, Your Honor.
Are you available, Ms. Constantine and Ms. McLemore and your witnesses? Are you available next Wednesday, either 11 a.m. or 1 p.m.? We can do it by Zoom if you like, or we can do it in person. I have no preference. If you're available on the 12th, Ms. Constantine?
Yes, at 1 p.m.
Ms. McLemore, check your schedule for me, please.
Yes, I am. I believe that date is good. So that would be the 11th? No, I'm sorry,
That's the 12th.
the 12th at 1 PM?
Yes, ma'am.
That would be good. I'm available, yes.
By Zoom or in person, Ms. Constantine?
By Zoom. I'm in Florida right now.
Zoom trial, April 12th, 2023 at 1 PM. Have your witnesses available and on time. If there are documents that you want the court to consider beforehand, you may email them to the civil department. They'll get them upstairs to me. I have the counter complaint as well as the attachments there too. Was there something else in this matter this morning, Ms. Constantine?
No.
Anything else, Ms. McLemore?
No, Your Honor, thank you.
I'll see you all next Wednesday. Have a good day.
Thank you.
Thank you. This is a recall of 230-827 LT. This is Rawsonville Woods versus Kaylee Tundis and James Wright.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Rawsonville Woods. I will advise the court that the parties did speak. They were unable to come to a resolution at this time. Was it the other parties wish to raise issues about the working with them in regards to assistance programs. But again, the parties were not able to come to a resolution. I don't think there's a dispute about the balance, but it's a more dispute about the fact that they're objecting to the assistance programs and my clients not working with them as much as they would prefer.
Mr. Morton, what is the rent to retain possession in this matter?
Rents retained are $2,269.56. Core costs of $188 for a total of $2,457.56.
Ms. Tundis,
Yes, ma'am.
you heard the amount of past due rent that Mr. Morton just placed on the record, the rent being $2,269.56, $188 in court costs.
Yes, ma'am.
Are you disputing the amount of rent that's claimed due and owing by the plaintiff?
No, ma'am. I just would like to be evicted and I need more time to move out.
Mr. Wright, do you dispute the amount of rent claimed due and owing in this matter?
I just have a question. When I go on the portal and I used to be able to see my bill for the next month, and I can't see that. So how am I supposed to know that those are the right charges?
Mr. Wright, because if my rent is $500 a month and I haven't paid rent in 3 months, I know that I owe $1,500, whether there's a portal or not. So if you're saying to me, hold on, my question to you was, do you dispute that the amount of rent claimed due and owing by the plaintiff, do you dispute that is $2,269.56?
Yes.
Yes, you dispute it.
Yes, ma'am.
If you dispute it, the court's happy to set it for trial, or we can take it up at the end of the docket this morning, which will probably be hopefully in the next 45 minutes or so.
Okay.
Mr. Ravis, Mr. Morton, do you have your witness available in the ledger?
Yes, I do, Your Honor. I can, if I can share the screen, I can share a ledger, and I have Ms. McKenzie present. Who's the manager, ready to testify?
Then let's do this. Let's pass this matter. Ms. McKenzie and Ms. Tundis and Mr. Wright go into a breakout room, share that ledger information. If the parties come to an agreement, come back out. Otherwise, after I finish all of the other cases this morning, I will swear witnesses and we'll take testimony in this matter, okay?
Thank you.
Thank you. We're getting to the 9:30 part of the docket. This is 230-834 LT. This is Holiday Woods versus Carla Bird. Ms. Bird or anyone at 20 Birch in Belleville. Mr. Morton, this case was scheduled at 9:30. It's now 10:11 by the court's clock. Not getting a response from the defendant. How are we proceeding this morning, sir?
I'm sorry, Your Honor. I was getting ready to leave. Was it to go into the breakout room with the other party? Could you just restate that case for me one more time? I apologize.
I'm sorry, Mr. Borden. I thought Ms. McKenzie was going in with them. This is 230834 LT Holiday Woods versus Carla Bird.
Thank
It was
you, Your Honor.
scheduled at 9:30. It's now 10:11 by the court's clock.
Thank you. Your Honor, at this time, based on Ms. Bird's failure to appear, we would ask a default judgment for possession be entered. Rents retained are $3,718.32. Court cost of $164 for a total of $3,882.32. This is a default judgment for possession only, Your Honor.
Thank you. Case being scheduled at 9:30, it being 10:12 by the court's clock, defendant having failed to appear, default judgment shall enter with total due to plaintiff of $3,882.32. That includes the court costs that are due and owing in this matter. This is 230915 LT Farmington Condo versus Mia Anderson. Your appearances, please.
Good morning, Grant Munson on behalf of the plaintiff.
I just saw Ms. Anderson.
Has anything changed in your life?
Ma'am, unmute yourself, state your name for the record for me, please.
She's represented by Lakeshore, I believe, and Ms. Cooper is on the line as well.
I am,
Oh,
Your
I
Honor.
do not have an appearance in this matter.
That's because I didn't have a chance to file it yet, Your Honor. I apologize.
Ms. Cooper, don't apologize. I'm happy to see you. It's been a while.
It has. Good morning, Catherine Cooper with Lakeshore Legal Aid on behalf of the defendant, PA 5148.
This is the second hearing in this matter. Ms. Cooper, how are we proceeding this morning?
We've reached an agreement, Your Honor. We're entering into a consent judgment. So the rental arrears are $20,775. I'm sorry, that's incorrect now. Whoops. The rental arrears
You
are
say $20,000. I was gonna stop.
Yeah.
Well, no,
It
that's
is $20,700, Your Honor. We have a missing Sarah check that we are trying to locate. And so the plaintiff's counsel has been kind enough to give Ms. Anderson until the 30th to either pay or vacate the premises. And so there's also a $75 court cost and a $75 attorney fee, bringing the total balance to $20,850.
the total, I'm sorry, the total balance is $20,775. The court costs were already included in the balance I gave, and then I added 75 for attorney fees. So we're entering into a consent judgment for the amount of $20,775 total to be paid on or before April 30th, or a writ of eviction to issue.
And Mr. Munson and Ms. Cooper, how long will it take you to get that signed consent judgment over to the civil department?
I can have it to you today, Your Honor. If I can get Mr. Munson's permission to sign on his behalf, I'll also email you a copy.
Yeah, as soon as I receive it, I'll give consent.
Thank you. Consent judgment, $20,775 with a pay or move date of April 30th, 2023. Ms. Cooper's office to submit that consent judgment for entry. Anything else in this case, Mr. Munson?
I believe he's in another
You're muted.
courtroom, Your
Anything
Honor.
else, Mr. Munson?
I'm sorry, no, nothing further from me, Your Honor.
Anything else, Ms. Cooper?
No, Your Honor.
Thank you. Ms. Anderson, you are free to go. Have a good day. Thank you for your patience this morning.
Thank you,
This
Ms.
is
Anderson.
230916 LT. This is Pristine Investments versus Tyra Smith.
Grant Munson for the plaintiff.
Tyra Smith or anyone at 28972 Whitby in Romulus. This case was scheduled at 9:30. It's now 10:15 by the court's clock. There's no response to the call from the defendants. Mr. Munson, how would you like to proceed?
Your Honor, at this time, I'm requesting a default judgment in the amount of $3,035 total. That's inclusive of costs and attorney fees, or a writ of eviction to issue on it'll be the 17th, on April 17th.
Mr. Munson, if you would break out the difference between rent to retain and court costs, please, sir.
Sure. So it's $2,885 in rent to retain, and then $75 court filing fee and a $75 attorney fee for a total balance of $3,035.
Defendant having failed to appear, the fall judgment will enter in favor of plaintiff and against defendant with the terms just placed on the record. If your office would email that over to the civil department for entry. Anything else this morning, Mr. Munson?
Nothing from me. Thank you.
Thank you. Have a good day, sir.
You too. Have a nice day.
Thank you. This is 2309560 LT West Village Estates versus James Bevel. James Bevel or anyone at 7008 Abilene Drive.
Jenny Shine on behalf of the plaintiff, Your Honor, that one was also dismissed.
Ms. Scheid, that's probably be the easier way to do it. The court has probably the next 7 cases, which are all from your office, where both parties failed to appear at the 3/22 date. And I wasn't sure if they should have been dismissed. So the next one is 23095 LT West Village versus Paul Durham.
No, that one's going through, and we did meet with Mr. Durham in a breakout room and have a consent agreement.
Where is he? Oh, Mr. Durham, would you turn your video on? State your name for the record for me, please, sir.
Yes, Paul Durham.
Take your hood off for me, please, sir. Thank you. Ms. Scheid, the terms of that agreement, please.
Yes, currently he has rent to retain of $2,160.33, court costs of $164.60 for a total owed of $2,324.93. This is for him to pay or vacate by April 21st, 2023. I did advise him of his rights under MCR 4.201I. I have his email address to send him a copy of this if he will consent to me signing on his behalf.
Mr. Durham, were you able to hear her just now?
Yes, it's $2,324.93.
Yes, sir.
I told
And
her I
sir,
was gonna
she
pay-
explained to you your right. I'm sorry, your question.
I said I was gonna pay. I said like I told her in the break room I was gonna pay in 2 portions, and by the 21st it should be all paid up.
And sir, she explained to you your rights regarding 3 days before this judgment is final?
3 days before the judgment is final. That
Because she represents West Village Estates and you're unrepresented, the judgment is not final and enforceable for 3 days?
what's
He doesn't have
that? What's that part?
Did she
I don't
explain to you
understand.
your appeal rights while you were in the breakout room, sir?
She explained to me that I was supposed to pay it by the 17th, but I asked her, can I get it to the 21st? And she said yes, she'd give it to me by the 21st. She asked Renee, was that okay? And Renee said, yes, that's fine. And I said, okay.
Mr. Durham, did I tell you that if you needed to, that you would have 3 business days in which to request that this be set aside for good cause?
Oh, yeah. This would be, she did tell me that would be set aside. Yeah.
Sorry, Your Honor, I use a little bit different.
And Mr., it's fine. And Mr.
I'm sorry.
Durham, that's okay. She further explained to you that because you appear by Zoom, there's not a signed consent. You authorize her to sign your name to that consent judgment.
Yes.
Did you have any questions regarding this matter, Mr. Durham?
No, I don't have no matter.
The plaintiff's office will submit a consent judgment to the court that shows a total of $2,324.93 to be paid on or before April 21st, 2023. I will sign it. A copy will be mailed to you at the address we have on file. Mr. Durham, unless you have any other questions, you're free to go, sir.
All right, thank you so much.
Thank you.
Thank you.
Ms. Samples is laughing at me. This is 23096 LT. This is West Village versus David Jones.
Jenny Shine on behalf of the plaintiff.
David Jones or anyone at 39056 Wyoming Drive. Today is the day and time set for the second hearing of this matter. Ms. Scheid, this was another one of those that neither party appeared on March the 22nd. How are we proceeding this morning?
We're requesting a default judgment be entered against Mr. Jones for failing to appear at today's hearing. Currently, there is rent to retain of $2,359.22. There's also court costs of $164.60 for a total owed of $2,523.82. It's my understanding that Mr. Jones is not in the military, a minor, or incompetent, and the property has been kept fit for its intended use. This would be for possession only.
Thank you. Case having been scheduled at 9:45, it being 10:21 by the court's clock, default judgment shall enter in favor of plaintiff and against defendant with total due inclusive of court costs of $2,523.82. Plaintiff's office to submit that judgment for entry. This is 230965 LT. This is West Village Estates versus Robert Merritt.
Jenny Scheid on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. There are no unidentified persons in the court's virtual breakout rooms. There is no one in the court's virtual waiting room, and the court has not received any indication from security that there's anyone downstairs waiting to get into the Zoom room. Ms. Scheid, this is another one where neither party appeared on March the 22nd. Based on the defendant's failure to appear this morning, how are we proceeding?
Your Honor, we would request a default judgment against Mr. Merritt for failing to appear at today's hearing. However, it is our understanding that Mr. Merritt is currently incarcerated. Renee, do you know if he's in Romulus?
No, his wife told me yesterday that he's in Jackson and quarantine right now. He will be there for 6 years. The wife already moved out. And I asked her if she got everything out of the home that she needed. She said yes. That is what I know. I'm going over there to do an inspection in just a little bit. If the weather holds out, if not, it'll be tomorrow, and I will make my office and the mortgage company aware of this as soon as I can get the inspection.
So at this time, we're still seeking a default judgment because we don't have keys to the place.
Correct.
From this court's perspective, if he is in fact incarcerated and there's someone else there, they should have appeared this morning or made themselves otherwise available to the court. So neither Mr. Merritt or anyone on his behalf is here. The court will enter the default judgment with the rent to retain. Ms. Scheid.
$2,083.47. Court cost of $164.60. Total is $2,248.07. For him to pay or vacate by April 17th, 2023, possession only. We just wanted to make sure that you were aware and be upfront with you that we had that information.
Thank you, ma'am. I've made that notation in the file. If something comes of that, we'll address it accordingly. Otherwise, the court will enter the default judgment. I'm prepared to call the Robert Lewis matter, and I know he was here.
He was, Your Honor, but that one was one where they had vacated already, so we had sent in a dismissal on that one.
This is 230972 LT West Village versus Robert Lewis and Tracy Ernest. I will make a notation in the file that there is a dismissal pending.
Yes.
Somewhere between downstairs and up here. Thank you. This is 230973 LT. This is West Village Estates versus Michael Navalta, Brittany Cleaver.
Jenny Scheid on behalf of the plaintiff.
Michael Navalta, Brittany Cleaver, or anyone at 38638 Tempe Drive in Romulus. This case was scheduled at 9:45. It's now 10:26 by the court's clock. No one is responding on behalf of the defendants. There are no unidentified persons in the court's virtual breakout room. There's no one waiting in the court's waiting room. Ma'am, how are we proceeding this morning?
We would request a default judgment for failing to appear at today's hearing. There is rent to retain of $2,117.45, court cost of $199.20, for a total owed of $2,316.65 for them to pay or vacate by April 17th, 2023. It is my understanding that defendants are not in the military, a minor or incompetent, and the property has been kept fit for its intended use by the plaintiff.
Thank you. Case having been scheduled at 9:45 being 10:26 by the court's clock, defendants having failed to appear. Default judgment shall enter against both defendants with a total due to the plaintiff, including court costs of $2,316.65. This is 230974 LT. This is West Village Estates versus Parker and Parker.
Your Honor, Jenny Scheid on behalf of the plaintiff. This is one where the defendants have vacated the property, therefore we sent in a dismissal.
That dismissal just has not reached the file yet, ma'am. I've made a notation in the file that it is forthcoming. This case will be dismissed. We are at the 10 o'clock docket. I am going to take the briefest of recesses, brief being less than 2 minutes. I'll come back out and I'll call in order Moody, Hill, Rice, and then Berg. Thank you.
Have a good day, Your Honor.
Thank you, Ms. Samples.
Ms. Scheid, how do you say your, I'm sorry, how do you say your last name? Scheid?
Madam Clerk?
Hello, Mr. Morton. Yes.
No, I was just gonna pass along a heads up that I did speak to Ms. Was it Tundis and Mr. Wright?
Right.
And the agreement has been reached, so that can be put on the record when the judge has an opportunity.
Okay, I'll let her know. Thank you.
Madam Clerk, Lee Ravitz on case number 6054 Wesley Townhomes versus Moody. We also have a consent judgment on that as well. That's a 10 o'clock case.
I'll let the judge know.
Thank you.
Welcome. The person who's identified as Bree Hill, can you hear me?
Yes, I can.
What case are you here for?
I'm the one with Aaron Hill. He's just at the doctor, so I was just on for him.
Oh, I think he's here and he's speaking with the attorney.
Okay. Let's see that.
This is 226054 LT. This is Wellesley Townhomes versus Moody.
Good morning, Your Honor. Lee Ravitz, B25314 on behalf of the plaintiff.
State your name for me, please.
Quatarius Moody.
Thank you. Today, I'm sorry, go ahead, Mr. Ravitz.
The parties have had the opportunity to speak in a breakout room and reach the terms of a proposed consent judgment. The rent to retain possession is $3,800.50, $164 in court costs, a total of $3,964.50, 3964.50. That'll be paid by April 24th. The writ could issue after that date. I explained to Ms. Moody her rights pursuant to the court rule, and she's going to obtain some help from the veterans, and hopefully they're going to take care of this on her behalf. She also gave me permission to sign her name to this proposed consent judgment.
Thank you. Today was the day and time set for hearing on the plaintiff's request to lift the Sarah stay. Mr. Ravitz has just placed the terms of a proposed consent judgment on the record. Ms. Moody, it's your understanding and agreement that stay is lifted and the consent judgment will enter with a total due of $3,000 $964.50,
Yes.
and that you will pay that amount or vacate the property by April 21st, 2023.
Yes.
And he explained your rights to you pursuant to court rule.
Yes.
And because you appear virtually, there is not a signed consent judgment. You've authorized Mr. Rabbit's name to sign your name to the consent judgment with the terms we just placed on the record.
Yes, ma'am.
Did you have any questions, Ms. Moody?
No.
Mr. Rabbit's office will get that proposed consent judgment over. The court will sign it, and copies will be mailed to you at the address we have on file, Ms. Moody. Thank you for your patience this morning. Have a good day.
You
Thank
too.
you.
Thank you.
You have a good day too,
Thank
Judge.
you.
Right.
Thank you, Mr. Rabbit. It's good to see you. Tell Katie I say hello.
I will. Thank you.
Thank you. This is 226115 LT. This is Park Estates versus Aaron Hill.
Judge, I believe that they're in the breakout room.
Thank you. This is a recall of 230827 LT Rawsonville Woods versus Tundus and Wright.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Rawsonville Woods, and the parties have reached a resolution.
Terms of that are, sir?
Was the parties have spoken. They've agreed to enter into proposed consent judgment. Rents retained are $2,269.56. Court costs of $188. For a total of $2,457.56. The payment date will be April 28th, 2023. I did advise both parties of their rights under the court rule, specifically the fact that the agreement's not final for 3 business days, taking into account Good Friday, as well as their right to appeal, and the fact that they gave me permission to put their name on the proposed consent judgment agreement, Your Honor.
Thank you. Ma'am, you were able to hear the terms that Mr. Morton just placed on the record,
Yes, ma'am.
and that is your agreement that there's a total due of $2,457.56,
Yes, ma'am.
and that you will pay this amount or vacate by April the 28th.
Yes, ma'am.
Mr. Wright, same questions.
Yep.
Put your face on the camera, please, and yes is the response.
Yes, ma'am. Sorry.
No worries.
Yep. Yes.
Yes?
Yeah.
Before you went to the breakout room, you expressed some concerns about the validity of the ballots. Mr. Wright, have your questions been answered regarding the ballots?
Correct.
And Mr. Morton, explain to the both of you your appeal rights and your rights to challenge the consent judgment.
Yes.
Yes.
And because you appear virtually, there is not a signed consent judgment. Have you authorized his office to sign the judgment for both of you?
Yes, ma'am.
Correct.
Thank you. Mr. Morton's office will present a proposed consent judgment that has the terms just placed on the record. The court will sign it and mail it to you at the addresses we have on file. Thank you for your patience this morning. You're free to go. Have a good day. Good luck to you.
You as
Thank
well,
you.
ma'am. Thank you.
Thank you, Your Honor.
Thank you. This is I'm sorry, Mr. Odatello, what are you here for, sir?
Oh, I'm sorry. I'm here on the Park Estates versus Mr. Hill. I was just in the breakout room with the attorney from what's it called? From Mr. Levin's office. I accidentally left. If I could please be put back in, Your Honor.
Absolutely, sir.
Thank you very kindly, Judge.
This is 230289 LT. This is GI&I versus Jordan Berg.
Your Honor, was it Attorney Ian Morton of Pallets Law on behalf of the plaintiff? For the record, I did speak to the defendant today because he had just recently came in and satisfied the judgment in full. So at this time, we're withdrawing the request for the order of eviction.
This case was scheduled at 10 a.m. It's now 10:35. The defendant has failed to appear. Mr. Morton, I heard your comments regarding the withdrawal of the request and the fact that he has satisfied the indebtedness. Just so we're clear, the reason I scheduled it for hearing is that the application for a writ showed payment of almost $4,300. And when we entered the judgment, there was $2,000 pending, and I wasn't sure how those numbers matched up. That was the only reason.
Understood, Your Honor. Yeah, that payment did incorporate that balance, but he has come in and satisfied the remaining portion.
Thank you.
Thank you. I believe that's my last matter until 11.
Mr. Morton, I was worried there for a minute. It looked like we were in the weeds, but we have appeared to have recovered. I'll see you at 11, sir. Thank you.
Thank you. I'm going to move myself into the breakout room, one of the breakout rooms to continue.
Thank you, sir. Marianne, I was nervous there for a minute. Oh, the dismissals came through at 9:57, Marianne.
What happened? You said rice. I'm still here. Hello?
Yes, Ms. Rice.
Oh, okay. I was wondering what happened. I didn't get my name called.
No, the attorney will be back in a second.
No, I'm confused. So do do I go in the breakout room still? I mean, I've never went to the breakout room before. So do
Oh,
I
yeah,
go?
you need to go to the breakout room so you can speak with the attorney.
Okay, could you transfer me there? I don't know how to do all this Zoom stuff. How do I do that? Oh, I see it. So is not too late for me to go there?
Nope, you need to click on that and go into the waiting room.
Okay, I'll do it right now.
Okay.
Thank you.
You're welcome.
Mary Ann?
Yes, ma'am.
They need you. They're out there eating Doritos and cheese sticks.
Oh,
I can't even. Absolutely not.
I was thinking about hooking them up at lunchtime anyway. I'll go take care of them.
I went out there just because I knew that there was nothing ready. And they were walking around with cheese sticks. I can't.
And it's 10:48.
And Doritos and pop. It looks like the world's worst road trip. Okay, so what's going on with these 10 o'clock cases?
Do you want me to get the attorney out here?
Not really. I'm trying to see if there's.
Oh, here they come.
Oh. I was just asking. Were you ready on Hill?
We are, Your Honor.
Ready to go, Your Honor.
226115 LT. This is Park Estates versus Aaron Hill. May I have your appearances, please?
Jenny Scheid on behalf of the plaintiff, P64886.
Odetella, P number 79707 on behalf of the Hills.
Mr. Odepella, do we have an appearance from you, sir?
No, you don't yet, Your Honor. I will file that today.
Today was the day and time set for hearing on the plaintiff's request to lift the emergency rental assistance stay that has been in place now for 90 days. Ms. Scheid, how are we proceeding this morning?
Your Honor, we are going to request that this be set for trial. Mr. Hill and his attorney have brought up some concerns regarding habitability. And so we are hopeful that we can still try to resolve it in the meantime. But at this point, I think the best thing to do is to set this for trial.
I'll get there in just one moment, but as for the stay, is there any reason why the stay shouldn't be lifted?
The stay should be lifted, Your Honor. It's my understanding that the SARA application has been denied and there has been no receipt of any additional funding from or through the SARA program.
Mr. Odetella, is that accurate? Thank you.
Yep.
So for the trial, I'm looking at next week, the 12th at 2 o'clock. Would that give you enough time to prepare, Ms. Scheid, and are you available?
Checking my calendar right now, Your Honor. I do not have anything on my schedule that would prohibit that. But a week is a short time period. Not sure if perhaps you might have something for maybe the 19th, just to give us enough time to also try to see if we can work this out. I don't know how Mr. Odetella's schedule is.
Your Honor, don't hate me, but I need to be until the 26th. I have a trial in North Dakota. So if we could please do it out till the 26th.
The 26th? Ms. Scheid, do you have any objection to that?
No objection, Your Honor.
Let's check the 20,000 calendars that we all maintain and see if there's anything. Mary Ann, is there something wrong with the 26th?
No, that's a good day.
Mr. Odetella, are you looking for an in-person or a Zoom trial?
Always Zoom, Judge.
Thank you so much. I can close
So
the
then
door,
next question to Ms. Scheid, AM or PM, do you have a preference?
PM is usually a little lighter on our schedule. We usually have a lot in the morning. But I know that you didn't ask me, Your Honor, but we usually do prefer them in person unless Mr. Odatala has some other reason. But we just find that trials with the exchange of documents and witnesses are usually easier in person.
No, that's Judge, if they prefer in person, that's fine. I look better in person anyway, so I have no objection to doing it in person.
So in person on the 26th at 1 p.m., Ms. Scheid?
Yes, Your Honor.
Mr. Odatella, is 1 p.m. good for you on the 26th?
That is perfect, Your Honor.
April the 26th at 1 p.m. in courtroom number 1.
I did speak with Mr. Odatala about, I was going to request an escrow order with the court, but because we're going to be having the trial before the next rent payment is due, I'm going to refrain from making that request then.
Thank you. The court staff will send out notices if there's anything if you're able to resolve this case before that April 27th date, please feel free to submit this signed consent document or settlement document to the civil department at the regular civil email address. Otherwise, I will see the parties here in person on the 26th at 1 p.m. It will be the only thing scheduled, so we will start promptly. Anything else, Mr. Odatella, this morning?
Your Honor, thank you very kindly for your time. I appreciate the diligence of the court. It's always wonderful.
Have a good day. Anything else, Ms. Scheid?
No, Your Honor. Thank you.
Thank you, ma'am. And you have one more case. Mr. Hill, you're free to go. Have a good day, sir. This is 226123 LT. This is Park Estates versus Daphne Rice.
She did check in, Your Honor, but unfortunately she's just recovering from surgery. And so she was not feeling well. And I know she'd already sat around for a little bit. So I did tell her that I would put this information on the record for her. Sorry, officially Jenny Scheid on behalf of the plaintiff.
And what information were you placing on the record, ma'am?
Your Honor, she has entered into a consent judgment with us. There is rent to retain of $1,322.46, court costs of $1,475.46. I'm sorry, that was the total.
I was going to say
court
there's
costs
not $1,000 in court costs.
No, I jumped the line. My eyes, yeah. Court costs are $153 for a total of $1,475.46. This is for her to pay or vacate by April 28th, 2023. I did advise her of her rights under MCR 4.201I. I do have her email address to send her a copy. She did provide consent for me to sign it. Ms. Kobish is here and can attest to that as well. She would have until the 17th for her to be able to appeal this.
I made the notation in the file. I remember seeing Mrs. Rice here indicating that she left because she's recovering from surgery. There was a consent judgment agreed to by between the parties that has a total due of $1,475.46 with a pay or move date of April the 28th. Your office will submit that consent judgment to the civil department for entry. And is that really it? Until 2:30?
I think so, Your Honor. I think you're probably sick of seeing me today anyway, so.
Oh, no, always a pleasure. And Ms. Kovic, thank you for logging on and hanging around. I'll see you this afternoon, ma'am.
All right, thank you. Actually, my colleague will be here for the afternoon cases.
Thank you.
But thank you, Your Honor. Take care.
And I see Mr. Pallett's, I'm sorry, Mr. Morton in with the 11 o'clock case. Mary Ann.
See, it all works out.
That's what I told Ken. I said, I felt like, oh, I said it to Ian, but out to Mr. Morton. I felt like we were getting in the weeds there a little bit. If Mr. Morton comes out, I'll be right back. There are just some dismissals that came in. I'll just print them out and add them to the file.
Okay. Um, Hello, is this running late? It's after 11 o'clock. Um, um,
Oh, where's my meeting? Where is my meeting? Where is my meeting?
Ms. Holler, you need to accept the invitation to go into the breakout room.
I did, but there was no one there. Okay.
I've been there, so yeah, so go accept the invitation to go into the breakout room, and then I'll be able to have a chance to be able to speak with you.
Okay. I'm just not seeing it.
Mr. Morton, I just stepped off and saw that you sent a response to the motion.
I guess, yes, but I would like to have if I have a chance to speak with Ms. Holler, I think we should be able to resolve this. So
I'm just having a hard time getting it. It's just not. Okay. I'm here. Can you
No,
can
you're
you
in
hear
with
me?
No,
Yes, ma'am.
Okay.
Ms. Holler, you should have received another invitation to the waiting room, which I can go in there as well. So if you could accept that.
You mean just right on the Zoom here?
Yes.
Okay. I haven't. I'll look again. Not seeing anything.
Okay.
Let's see if Mary Ann can help you in getting where you need to be.
Okay. I did get one a few minutes, maybe about 10 to that's invited me to the waiting room. So I went on it, but no one was in there. So I wanted to, go back to I went back to the courtroom for 11 o'clock.
My secretary is sending you another one, so please go
Okay.
where she's sending you. Thank you.
Okay. Thank you, Your Honor.
Do you see the invitation, ma'am?
No, I'm sorry, I don't. I'm just getting the screens with everyone on it.
Ma'am, when you touch the screen, what comes up?
I see Your Honor, and then when I slide to the right, I see Mr. Morton and Your Honor, and then I just see Mary Ann, and then I see just a picture of myself.
Do you remember how you got into the waiting room before?
Yes, it came up as soon as I logged in, you were having a proceeding with someone else. And so it came through for Mary Ann to invite me, I got the invite, and then I just clicked on it and I was there in the waiting room. And then it got, no one was there. It was like an empty chair. And then I waited for, I wanted to get back into the courtroom at
Ms.
11,
Holler?
so I left the waiting room.
Ms.
Yes.
Holler? I
Yes.
just sent something to you. Do you see that?
Yes, I see it. Okay. So I'll
Go
click
there,
on it now.
please.
Thank you.
Please, thank you.
Okay, thank you.
Mr. Morton, I put her in your waiting room. So if you meet her in the waiting room, please.
I will go in there, Your Honor.
Thank you, sir.
That's what I always say before.
Marianne, is there a tornado warning in effect, maybe?
I'm sorry, what did you say?
Tornado. I
I
said
had-
tornado warning. It's a tornado watch, it looks like.
Yeah, I haven't heard anything.
It just
I mean, I
popped
haven't,
up.
yeah, I haven't heard sirens or anything.
Tornado watch as of 8:38 this morning. until 4. Oh,
Yeah, my friend who lives in Colorado sent me an email this morning. She said, hang on, I heard you guys are gonna have horrible weather today.
it just popped up on the bottom corner of my monitor. Uh-oh.
Thank you, Your Honor, for guiding me, helping me guide me through that.
No worries. I try to remind people, everybody that's not on Zoom every single day like we are, and it just takes a little use to figuring out
Yes,
how to
thank you. I
navigate
appreciate
this.
it.
No worries. This is 230176 LT. This is Holiday Woods versus Leslie Ann Haller and Lindsay Haller. Your appearances, please.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Holiday Woods.
Ma'am, would you state your name for me, please?
Leslie Ann Haller.
Thank you. Today is the day and time set for hearing on your motion to set aside the default judgment. Mr. Morton, you've now had an opportunity to speak. Have the parties reached an agreement?
Yes, we have, Your Honor. The parties have spoken. I've spoken to Miss, is it Haller?
Yeah, Haller.
Haller, thank you.
Thank
I
you.
spoke to Miss Haller. This was a lease agreement that she entered into along with her daughter. I'm not going to go into the detail, some of the extended details that I've been provided. However, the parties have agreed to enter into a stipulated order to set aside the judgment and dismiss the case as to Miss Leslie Haller only. Miss Haller has confirmed, which will be on the order itself, that she does not live there. She does not have possession of this unit and does not wish to continue to have, does not wish to have possession of this unit. She understands that she did sign the original lease agreement, so that liability does retain. But we agreed today to set aside the judgment and dismiss this case without prejudice, which Ms. Haller will then be able to have for her records as well. Although I will say when it comes to Ms. Lindsay Haller, Your Honor, for the court, we did submit an order of eviction request, and we do intend to continue to move forward on that to obtain possession of the rental premises.
Before I inquire of Ms. Leslie Haller, I want to be clear to you, Mr. Morton, that the court has received the response to the motion that was filed late yesterday. And just so that your office understands, the reason why I asked staff to set the hearing is that Ms. Haller made statements in her motion indicating that she had not been served and she lived at a different address. Because there was no lease attached to the summons and complaint in this matter, the court was not sure of any specifics about where notice should be sent. That being the case, and the parties having appeared this morning, Ms. Haller, you were able to hear Mr. Morton regarding the settlement that had been reached.
Yes, I have, Your
As
Honor.
relates to you. And it's your agreement that there will be a stipulation with a proposed order signed that sets aside the judgment as to you and dismisses the case as to you.
Yes, I understand.
And you've confirmed to Mr. Morton that you don't live there, you've never lived at the subject property, and you have no interest in the property, that property being 214 Magnolia Place, site 214 in the city of Belleville.
That is correct, Your Honor.
And Mr. Morton, are you circulating that stipulation to Ms. Haller, or have you received authorization to sign it on her behalf?
That's the one thing I did not get to. Ms. Haller, I wanted to confirm that I have permission to sign your name to the proposed, was it stipulated order to set aside the judgment and dismiss the case that we discussed? Was it with the terms that we discussed? The only other thing I would want to do is confirm your address. We can put that in the record, and then I can write that down, so that will be on the stipulation, so you will receive a copy.
Yes, that's fine. My address is 7130 Jennings Road, JENNINGS Road, Whitmore Lake, WHITMORE Lake, Michigan, 48189.
48189. So, and then
Yes.
do I have your permission to sign your name to the stipulation to set aside the judgment and dismiss the case as to you?
Yes, I give you permission, Mr. Morton.
Thank you.
Thank you.
Thank you. There's a notation in the file now that the stipulation is coming as a matter of just logistics to keep the file clear, Ms. Haller. You will also be receiving a copy of an order that denies your motion to set aside the judgment. So your motion is denied, but there's a stipulation coming. The
Okay, thank you,
outside
Your Honor.
issue, thank you, ma'am. The outside issue is that there is an application for an order of eviction filed by the plaintiff's office back on March the 10th.
Okay.
Lindsay Haller has not appeared this morning, has not taken any steps with this court since entry of the consent judgment previously. For that reason, Mr. Morton, if it's your client's intention to proceed with the application?
That is correct, Your Honor. And we would just move for the court to strike Miss Leslie Haller from that order of eviction.
I am striking Leslie Haller from that order. The order is now signed and will be processed in the usual regular fashion of the civil department. So 2 orders and a stipulation forthcoming. Anything else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Haller?
No, thank you, Your Honor, and Mr. Morton. Thank you.
Absolutely, ma'am.
Thank you for your patience, ma'am. Have a good day. Good luck to you.
Thank you so much.
You're welcome. Mr. Morton, I think that's it for us until 1:15.
That sounds accurate, Your Honor.
I'll see you then, sir. Thank you.
Thank you.
Mary Ann, we will stand in recess until that time. Thank you, ma'am.
Okay.